plans lost in the Madoff fraud. Upsher-Smith Laboratories is a family-owned pharmaceutical company. The company was formed in 1919 and has approximately 550 employees in the Twin Cities, Denver, and around the country. In 1974, our owners established a profit-sharing plan to share the profits with our company's employees, and beginning in 1995, the plan assets were invested with Mr. Madoff. Over the next 12 years, the company contributed over $8 million to the plan for the benefit of our employees. On December 11, 2008, Mr. Madoff was arrested for fraud, and approximately 615 of our current and former employees lost their retirement savings that had been in the profit-sharing accounts invested with Mr. Madoff. Our plan and our plan participants are representative of the average American workers whose retirement savings ERISA was intended to promote and whose investments SIPC was intended to protect. Of our 615 plan participants, approximately 550, that's about 89%, had contribution balances of less than $50,000. This plan covers the average American worker. Yet SIPC has stated that only a single recovery of $500,000 is available. This is because the plan's account with Mr. Madoff was held in the name of the plan trustee. But this was required by an administrative requirement imposed by ERISA that plan assets must be held in the name of the plan trustee and not in the name of individual plan participants. Our plan lost in excess of $8 million in contributions in the Madoff fraud. If one includes the false Madoff profits, that number would be in excess of $18 million. A single SIPC recovery of $500,000 will not go far to cover the losses of our individual plan participants. The administrative rule of ERISA requiring that plan assets be invested in the name of a plan trustee cannot be allowed to defeat the public policy behind ERISA to promote retirement savings of average American workers, nor can it be allowed to defeat the public policy behind SIPC to protect the investments of average American investors. For most Americans, their primary investments are held in their pension plans, profit-sharing plans, and other qualified retirement plans. If the administrative rule of ERISA is allowed to defeat SIPC protection for the losses of individual plan participants, then SIPC fails to protect the investments of the average American worker as Congress intended when it adopted the Securities Investment Protection Act and created SIPC. This in turn undermines the public policy of promoting savings and providing retirement security for average American workers through pension, profit sharing, and other qualified plans as Congress intended when it adopted ERISA. The FDIC offers a parallel for what we propose here. If a profit-sharing plan invested in its assets in FDIC-insured deposits, even though the deposits were held in the name of the plan trustee, the FDIC would cover each plan participant up to the FDIC limits. We have been asked by a congressional staffer in the spring whether it's possible as a matter of policy to extend SIPC protection to cover the losses of individual participants of pension plans invested with Madoff and not also extend such protection to individual investors of feeder funds who invested with Mr. Madoff. With great compassion for those individual investors and great compassion for Ms. Langford, we believe that the answer is yes. As a matter of public policy, a distinction can be made, though we of course support any relief that can be given to the individual investors in feeder funds. ERISA prevents individual plan participants from investing their retirement accounts directly in their own names. The situation differs for individual investors in feeder funds. They are not prevented by federal legislation from investing directly in their own names. Nor is their investment governed by the public policy of encouraging worker savings as embodied in ERISA. For these reasons, if a distinction must be made on a policy basis, we believe it is possible to provide SIPC protection for the losses of plan participants of ERISA plans, though again we do support relief for investors in feeder funds. Thank you for your time and attention and consideration of this important legislation to extend SIPC protection to the claims of individual participants of pension, profit sharing, and other qualified retirement plans.
Thank you very much, Mr. Green. And now I turn to my colleague from Florida, Mr. Klein, to introduce the third witness. Mr. Klein.
Thank you, Mr. Chairman. It's my honor to introduce Helen Chaitman, who is a partner in Phillips Nizer Limited Liability Partnership in New York. She's the author of The Law of Lender Liability, is counsel to the Madoff Coalition for Investor Protection, which is a combination of a number of investors who lost assets in the Ponzi scheme, and has been someone who I think has had a fairly good crystallized view of the issue and has been helpful to me and many others in understanding the nature of what went wrong and what should be done to resolve it. Ms. Chaitman.
Thank you, Congressman Klein. Chairman Kendrowski, thank you so much for having me here. Distinguished representatives, I thank you as well. It's just about a year ago that I learned that I had lost my life savings and my grandson's college fund in Mr. Madoff's limited liability company. And it took me a little bit of time to get over the shock and devastation. And when I did, I realized that I was one of the lucky ones because I'm still working and able to support myself. And I devoted myself for the next 6 months to working completely on a pro bono basis, helping hundreds of destitute Madoff investors in their 70s, 80s, and 90s who had been hit by a financial tsunami from which they can never recover. This committee has dealt with that financial tsunami in the Investor Protection Act of 2009, and I'm not here to speak about that. But unfortunately, the Madoff investors whom I represent, and I represent hundreds of them, have been hit by 2 additional financial tsunamis that this committee can do something about. My client profile is a person in his 70s, 80s, and 90s who worked hard his whole life, who trusted this government. Many of my clients served in the Second World War with distinction. I have clients who were disabled in the Korean War and will receive medals for their service. They trusted this government, and they worked as honest, law-abiding citizens. They worked in professions, they built up businesses, and when they reached retirement age, they retired and they put their money in an entity that had been blessed repeatedly by the SEC. And Mr. Madoff bragged to potential investors that jealous funds had complained to the SEC about his results, and he had been repeatedly investigated and always come out clean. These are people of whom we should be proud and whom we should be protecting. And instead, these people have been victimized by the government since December 11th, 2008. The second tsunami that hit my clients was the announcement by SIPC, with the blessing of the SEC, that the statute that this committee played a key role in drafting in 1970, that statute doesn't mean what it says. My clients relied upon the promise of SIPC insurance as required by the Securities and Investor Protection Act. They invested in Madoff knowing that the first $500,000 in their accounts was insured by SIPC. They invested in Madoff knowing that Congress mandated that upon the liquidation of a broker, SIPC must promptly pay up to $500,000 by replacing securities in a customer's account. The statute mandates how a customer's claim is to be determined. Net equity is clearly spelled out in the statute. It's clearly spelled out on SIPC's website, even today. And yet SIPC has decided that it doesn't insure the first $500,000 in the accounts. It only insures the net investment going through generations of investors, because a lot of my clients are people whose grandparents invested in Madoff. And what SIPC is doing is going back 3 generations to net out investments, and they're discounting inherited balances unless the investor can come forward and prove how much the grandfather deposited into the account in 1970. A virtual impossibility. Nobody keeps records going back that far. And nowhere did the government put people on notice that if they want to have a SIPC claim, they have to keep their records going back 30 and 40 years. So the second tsunami was SIPC's defiance of net equity. And we know from Mr. Conley's testimony, which was posted yesterday on the website, that the SEC doesn't feel it's bound by the statute. American citizens have to trust in the laws. If the statute gives them a promise of insurance, they have to rely upon that. And how can we as a country instill confidence in the capital markets if we don't stand by our laws and if we fund a governmental agency which defies the law? The SEC has now taken a position that people who delegate to their broker investment decisions don't get insurance as defined by the statute. They don't get net equity. The SEC announced yesterday they get their net investment plus some adjustment for the increase in the decrease in the buying power of the dollar over a period of 30 or 40 years. Well, what's the purpose of this committee deliberating so carefully on a statute if the SEC can then, after there's been a big loss, decide, we don't think Congress got it right, and we don't feel we have to go back to Congress. We're going to decide what the law is. How can we make people feel comfortable that they are protected by this government, which they served and to whom they paid taxes, if the SEC, funded by taxpayer dollars, can thumb its nose at this institution? The third tsunami that my clients have been hit with is that the SIPC trustee has taken the position that he can demand repayment of all withdrawals within the last 6 years, even mandatory withdrawals from IRA accounts on which people paid taxes, if the net investment going back for generations is a negative number. So let me give you one very simple example.
Time is almost...
My time is up?
Yes.
All right. You'll have to look at my written testimony then for the example. Thank you so much,
If you want
Chairman.
to state the example, we'll take that.
Well, thank you so much. If my grandfather put $500,000 into Madoff in 1970, and he died in 2003, at which time the account was worth $3 million, and I took $1.5 million out of that account to pay the estate taxes, and then from 2003 to 2008, the account went from $1.5 million to $2 million. Mr. Picard would be saying to me, pay me back $1 million. Your grandfather put in $500, you took out $1.5 million to pay estate taxes, you owe me $1 million. So my clients who have lost their life savings, who were forced to sell their houses in a down market, and who are cherishing the tax refunds that they have received as the only funds they have to live on for the rest of their lives, now are faced with giving up those monies in order to do what? Nobody wants that. I, as an investor, never took money out of my account, and I, in theory, am the beneficiary of the clawbacks. I and many of my clients who are just like me, never took money out, don't want this money. This is blood money. These people are entitled to keep what they took out. Thank you.
Thank you very much. Now, the rules do not allow demonstrations. I appreciate it. I know this is an emotional time, so we'll be a little lenient with the rules, but really that's not right. And now we'll hear from our friend from Colorado to introduce the fourth witness, Mr. Perlmutter.
Thank you. And I appreciate the witnesses being here today and the straightforward testimony that you're giving to all of us. And I just want to lead with this. I think that we have four things that we have to consider. One of them